Judicial Branch, one of my favorite three branches. Yeah. Who are they? What do they care about? Why do we care about them? Well, let me tell you about that. The Judicial Branch is the court system in the US. This was a really new idea in 1787 because courts in other countries were tied to other branches, not an independent system. This means that in the US, they are free to interpret the laws in the fairest way possible without fear of losing their jobs. In the US, we have a lot of different levels of courts. Every level of government has its own court system, with some overlap when a person appeals or asks the court to rehear their case. Not all cases can be appealed, but as checks on the system, people can request an appeal if they think the incorrect decision was made, or really if something was done wrong in their case. So if your judge was reading Cosmo and not giving the jury fair instructions, you can appeal to get a new trial. Even at the federal level, we have a lot of courts. There are trial courts, appellate courts, and other courts outside the normal courts, like tax courts. But the one that we really are going to talk about today is the Supreme Court. The Supreme Court has 9 justices. One of them is called the Chief Justice. The other 8 are associate justices. The Chief Justice does not have more power than the others. He or she just runs the process in court so things move along more smoothly. These 9 people have a job for life. According to Article 3 of the Constitution, the Supreme Court justices serve a life term. And to be one, you simply have to get appointed by the President and approved by the Senate. No age limit, no previous experience, no citizenship requirement. Once you're in, it's a lifelong club. You die, you resign, or you get impeached for doing something illegal. Sounds pretty easy to keep your job for life, right? Let's all be justices. So once you have the job, what exactly do you do? I'm glad you asked. The big power that the Supreme Court has is called judicial review. This power is not actually spelled out in the Constitution, but started in 1803 with the case Marbury versus Madison. Now, we don't care about the specifics on that case, but really Marbury was suing Madison for his job. Marbury went straight to the Supreme Court using a law Congress had passed. The court ruled that yes, Marbury was right about his job, but too bad because the law he used was unconstitutional, so his case should have never been in the Supreme Court and got thrown out. This was the first time judicial review was used. The Supreme Court can actually look at actions like laws that the other 2 branches do and decide if they're actually constitutional. If they aren't, they just throw them out. So take that, Congress. Want the law anyway? You have to amend the Constitution. This judicial review can also be used to set precedents, court cases that all the other courts use to make their decisions. Once the Supreme Court makes a decision, it has the power of a law, and all other courts have to do the same thing. The only group that can change a precedent is the Supreme Court. Like with Brown versus Board of Education, they changed from separate but equal to separate is not equal. It took 60 years for them to change it, but they did it. So it takes a group of 536 to make a law, Congress plus the President, and 5 people can get rid of it. Pretty powerful group, right? So maybe we don't want just anybody on the Supreme Court. One of the main things we want justices to be is nonpartisan. This really means we want our justices to make decisions based on the Constitution and their interpretation of the Constitution, not based on any political party beliefs. By giving justices a job for life, they can do this without being fearful that a decision they make will cost them their job. It helps justices to be unbiased. Does that mean that they're always unbiased? No, of course not. No system is perfect. So how can you get your case heard before the Supreme Court? Not very easily. You can be one of the few that get to go there first, known as original jurisdiction. That includes being 2 states in a case between you. I don't think any of us are states. And being an ambassador or representative of a foreign government. Maybe we should try appellate jurisdiction instead then. Appellate jurisdictions means we can appeal our case to the Supreme Court. About 150 cases are heard each year by the court, and over 5,000 are appealed to them. They actually get to pick the cases they want to hear. They have clerks who read all the cases, then pass on the ones they think each justice may want. The justices meet and talk about which cases to hear. If 4 of the 9 justices want to hear a case, they hear it. That's for 1. Now you have another 149 to pick. Cases are argued before the court on Monday, Tuesday, and Wednesday from October to June. After that, justices do research, write their decisions, and why they made those decisions, that's called their opinions, and prepare for the next year. Cases can be argued months before a decision is made. Decisions take a majority, which is usually 5 of the justices. If 5 agree, everyone in the country does it from now on. That's power. When courts, whether it is the Supreme Court or not, make decisions about laws being legal or not. It's called judicial activism. We've seen this with gay marriage laws. Court decisions are taking state laws and overturning them. Ultimately, these cases go to the Supreme Court, so the entire country has the same precedent to follow, but it can start in lower courts. So for a group that had just a short blurb in the Constitution, the Supreme Court is an incredibly powerful group of 9 people. Maybe even the most powerful 9 people, because they can influence policy for 40 years, not just for 4. Maybe when I grow up, I'll be a Supreme Court justice.